Hello viewers, I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In the present module, we will learn about the Hindu joint family, concept, nature and composition. Introduction, then nature, composition and membership of Hindu joint family, main features of Hindu joint family and then conclusion. Let's begin with a brief overview. A Hindu joint family is a unique kind of family where several generations with a common ancestor live together under one roof, share a kitchen, a place of worship and own an estate. Without a common ancestor, a joint family cannot exist. Although this does not imply that the ancestor must always be present. It is crucial to bear in mind that a Hindu family may continue to exist as a joint family even in the absence of a common kitchen, roof or place of worship. The most important component is a common estate or common nucleus of the family. According to Shrimati Iravati Karve, a joint family is a group of people who generally live under one roof, who eat food cooked at one hearth, who hold property in common and who participate in common worship and are related to each other as some particular type of kindred. K. Davis explains that the joint family consists of males having a common male ancestor, female offsprings not yet married, and women brought into the group by marriage. All of these persons might live in a common household or in several households near to one another. In any case, so long as the joint family holds together, its members are expected to contribute to the support of the whole and to receive from it a share of the total product. Dear learners, let's discuss the nature, composition and membership of the Hindu joint family. The joint family, with all its incidents, is a creature of law and cannot be created by act of parties, except to the extent to which a stranger may be affiliated to the family by adoption. A joint Hindu family is neither a corporation nor a juristic person, as it does not have a separate legal entity from that of its members, as was held in Chote Lal and others versus Jhandelal and another 1972. It is a unit and is represented by the Karta of the family in all matters. If the daughter is deserted by her husband or becomes a widow and returns to her father's home permanently, she again becomes a part of that Hindu joint family. Her children, however, remain a part of their father's joint Hindu family and do not become a part of mother's father's joint Hindu family. It was observed in the case of Gur Narayan Das versus Gur Tehal Das that even an illegitimate son of a male descendant will be part of his joint Hindu family. Now let's discuss main features of Hindu joint family. So far, we have discussed that Hindu joint family is a closely unified social group whose members live under one roof in a large home of many rooms. The financial resources of the family are pooled and the family has a leader or executive head. He is usually the oldest and most respected male present. The essential features of a Hindu joint family are: first one, creation of law. As discussed earlier, the joint Hindu family with all its incidents is thus a creature of law and cannot be created by act of parties. However, a stranger may be affiliated with the family by adoption. It does not arise from any agreement among the members, but rather from the operation of law. It is essential to remember that a joint Hindu family does not have a separate legal existence apart from its member. In Chotelal and others versus Jhandelal and another, 1972, the learned counsel for the plaintiff respondent submitted that if a deity or an idol can hold property, so can a joint Hindu family. The court observed that comparison is neither apt nor appropriate. The Hindu law recognizes a deity or idol to have a juristic personality, entitling it to hold property. But as seen above, the rules of Hindu law do not clothe the joint Hindu family with such a status. Hindu law does not recognize a joint Hindu family or kopasnari as a juristic personality capable of holding property as entity separate from the members of the family. When it is popularly said that a property is joint family or kopasnari property, the true position in law is that the members collectively own it, each having an interest. In Mahavir Prasad Badridas versus M.S. Yagnik, 1960, the court held that the property belonging to a Hindu undivided family is the ownership of the kopasners in that family, and that such a family is not a corporation. It is not a judicial entity distinct from the members who constitute it. It cannot sue or be sued in the joint family name and cannot convey the property held by it in its joint character. The kopasners who are members of the Hindu undivided family are undoubtedly owners of the property. But a Hindu undivided family has an independent existence apart from the individuals who constitute the same. Next one, unique nature. The joint Hindu family is a unique concept of both Indian society and Hindu jurisprudence that has seen no other parallel in the ancient or the modern system of law. It is a fundamental aspect and a characteristic feature of the Hindu life. It provides social security while also playing a major role in other social, political and economic institutions. All the members of a joint family keep their earnings in a common fund, out of which family expenses are met. Accordingly, the Indian joint family system is like a socialist community in which every member earns according to his capacity and receives according to his needs. This joint family or extended family is organized on close blood relationships. It normally consists of members of 3 to 4 generations. Next one is presumption of jointness. As discussed earlier, there is no need for a joint family to live jointly in one house, and often smaller joint families, for example, a couple with an adult married son or even a minor son, because they have an interest by birth in the father's property, form a part or a branch of a larger joint family, the branches of which may have separate residences, though they are joint in status with the larger joint family. The law presumes that the members of a Hindu family are joint till partition is proved. It is for the party who pleads that a member of the family had separated himself to prove it satisfactorily. For the existence of a joint family, the family as such need not possess any property, since it is not the property but a relationship that knits the members of a family together. In MST Rukmabai versus Lala Lakshmi Narayan and others, 1960, the court observed that there is a presumption in Hindu law that a family is joint. There can be a division in status among the members of a joint Hindu family by refinement of shares, which is technically called division in status, or an actual division among them by allotment of specific property to each one of them, which is described as division by metes and bounds. A division in status can be affected by an unambiguous declaration to become divided from the others, and that intention can be expressed by any process. Next one is unity of ownership. Hindu law does not recognize a joint Hindu family or coparcenary as a juristic personality capable of holding property as an entity separate from the members of the family. When it is popularly said that a property is joint family or coparcenary property, the true position in law is that the members collectively own it, each having an interest. In Mahavir Prasad Badridas versus M.S. Yagnik, 1960, the court held that the property belonging to a Hindu undivided family is the ownership of the coparceners in that family, and that such a family is not a corporation. It is not a judicial entity distinct from the members who constitute it. It cannot sue or be sued in the joint family name and cannot convey the property held by it in its joint character. The coparceners, who are members of the Hindu undivided family, are undoubtedly owners of the property. But a Hindu undivided family has an independent existence apart from the individuals who constitute the same. Next one is common ancestor. The features of a Hindu joint family include a common ancestor, which is a very fundamental element of all joint families, such that without it, no joint family can come into existence. However, the existence of a common ancestor is not necessary for its continuation. In case of the death of the common ancestor, the rest of the family continues to be a joint family till partition is effected. Next is membership and composition. In Surjit Lal Chhabra versus Commissioner of Income Tax 1976, the Supreme Court lucidly explains Hindu joint family as follows. A joint Hindu family consists of persons lineally descended from a common ancestor and includes their wives and unmarried daughters. The daughter, on marriage, ceases to be a member of her father's family and becomes a member of her husband's family. The joint Hindu family is thus a larger body consisting of a group of persons who are united by the tie of spindaship, arising by birth, marriage, or adoption. The fundamental principle of the Hindu joint family is the spindaship. Without that, it is impossible to form a joint Hindu family. With it, as long as family is living together, it is almost impossible not to form a joint Hindu family. It is the family relation, the spinda relation, which distinguishes the joint family and is of its very essence. A child in the womb is also treated as a member of the Hindu joint family for certain purposes. But for taxation purposes, the child is not treated as a member of the Hindu joint family till it is born, as was held in S. Srinivasan versus CIT 1962. An insane member, whether male or female, cannot be a coparcener. However, such an individual is a member of the joint family. In case of partition, a share has to be allotted in favor of the insane member. Even an illegitimate offspring of a male descendant is a part of the father's joint Hindu family, according to the case of Gur Narayan Das versus Gur Tehal Das, 1952. Members of it are kin, which entails their relationship through blood, marriage, and adoption. Next is cessation of membership. A member of a Hindu joint family loses his or her membership in the following circumstances. Firstly, conversion. If an individual who is part of a Hindu joint family converts to another religion, he ceases to be a member of the Hindu joint family. Nonetheless, a person will still be covered in the definition of Hindu if they convert to or from any of the following religions: Jainism, Buddhism, Sikhism, or Hinduism. Consequently, in such cases, there will be no cessation of membership, and the individual in question will continue to be a member of the Hindu joint family. Secondly, marriage under the Special Marriage Act. A person no longer belongs to the Hindu joint family if they marry a non-Hindu under the Special Marriage Act of 1954. Next is adoption. A child who has been adopted by a different family no longer belongs to his birth family and joins as a member of the adoptive family. Next is by marriage of a daughter. An unmarried daughter ceases to be a part of her father's joint family on her marriage. However, the amendment of 2005 has made a daughter a co-partner in her father's family. Therefore, after her marriage, she becomes a member of the Hindu joint family of her husband but remains a co-partner in her father's family. Next is Karta. It is a unit that is represented in all family matters by the joint family's manager known as the Karta. He is usually the oldest and most respected male present. Next is copartnery. A Hindu copartnery is a much narrower body than the joint family. It includes only those persons who acquire by birth an interest in joint or copartnery property. These are the sons, grandsons and the great-grandsons of the holder of the joint property for the time being. In other words, the 3 generations next to the holder of unbroken male descent. Prior to the 2005 amendment, all male descendants of a common ancestor in a Hindu joint family up to 3 generations in length comprised a more confined institution known as copartnery. The copartners are entitled to the joint family's ancestral property by birth. The 2005 change, however, gave the girls the same status as the males and made them members of the copartnery. Next is common nucleus. For the existence of a joint family, the family as such need not possess any property, since it is not the property but a relationship that knits the members of a family together. Where the 3 brothers lived and worked in different places and owned only a house in common and had not effected a partition, it would still comprise a Hindu joint family. Next is community of interest and unity of possession. The Privy Council in Katamma Nachiyar versus Raja of Shivganga 1863 observed that there is a community of interest and unity of possession between all the members of the family. It is thus clear that the members of the joint family collectively own the copartnery property. Each member has an interest in such property, though his interest becomes definite on partition. Until then, it is an undivided interest. Next is Hindu undivided family without undivided family property. In Surjit Lal Chhabra versus Commissioner of Income Tax 1976, where a Hindu male along with his wife and daughter claimed to constitute a Hindu joint family, the Supreme Court held that it does not take more than 1 male to form a joint Hindu family with females, which is well established. The court further observed that even in the absence of an antecedent history of jointness, the appellant could constitute a joint Hindu family with his wife and unmarried daughter. However, the appellant could not constitute a copartnery with his wife and unmarried daughter. A Hindu copartnery is a much narrower body than the joint family. Next is sole surviving copartner. In Anant Bhikappa Patil versus Shankar Ramchandra Patil, 1944, it was held that on death of a sole surviving copartner, a Hindu joint family is not finally terminated so long as it is possible in nature or law to add a male member to it. Thus, there can also be a joint family where there are widows only. The family cannot be at an end while there is still a potential mother, if that mother, in the way of nature or in the way of law, brings in a new male member. The court further observed that the adopted son is the continuator of his adoptive father's line, exactly as an Aurus son, that is, natural son, and that an adoption, so far as the continuity of the line is concerned, has a retrospective effect. Whenever the adoption may be made, there is no hiatus in the continuity of the line. Dear viewers, let's discuss advantages of the joint family system. This joint family system included economic, sociological, and psychological advantages. On the economic side, the family was a kind of social security system. When child marriages were frequent, the young newlyweds were taken care of by the family until the bridegroom was able to work and earn something in support of the family. All the incomes were pooled and were dispersed according to the needs of each member of the family. The final decisions over economic disbursements were made by the head of the household, usually the oldest male. In case of illness, marriages, deaths, or other events requiring expenditure, the family was able to supply the needed money or resources to pay for these requirements. A member of this joint family felt that he was being looked after and that his contribution helped others in the family. Marriages were always arranged by the family, and these ensured a distinct measure of cultural and religious similarity between partners. Since such marriages generally took place with reference to caste, religion, and social status. What is Hindu undivided family? As per the provisions of the Income Tax Act 1961, under Hindu law, an HUF is a family that consists of all persons lineally descended from a common ancestor and includes their wives and unmarried daughters. An HUF cannot be created under a contract. It is created automatically in a Hindu family. Section 2, Clause 9 of the Income Tax Act 1922 defines a person to include inter alia a Hindu undivided family. Under Sections 3 and 55 of that Act, a Hindu undivided family is a separate taxable unit for the purposes of income tax and is assessed as such in subsequent assessment years till partition is claimed by copartners. In Gauli Buddanna versus Commissioner of Income Tax Mysore, one Buddappa, his wife, his two unmarried daughters, and his adopted son Buddanna were members of a Hindu undivided family. On Buddappa's death, a question arose whether the adopted son, who was the sole surviving copartner, could form a joint Hindu family with his mother and sisters and could accordingly be assessed in the status of a manager of the Hindu undivided family. The court held that under the Hindu system of law, a joint family may consist of a single male member and widows of deceased male members, and apparently the Income Tax Act does not indicate that a Hindu undivided family as an accessible entity must consist of at least 2 male members. Dear viewers, let's conclude the present lecture. The present module may be concluded with the observation that a Hindu joint family is a family unit in which multiple generations live together and are related through a common ancestor. It's also known as a Hindu undivided family, that is HUF. A Hindu joint family is created by law and not by contract. In India, there is a presumption that every Hindu family is joint. The joint and undivided family is the normal condition of Hindu society. An undivided Hindu family is joint not only in estate but also in food and worship. However, the possession of joint property is not a requisite for the constitution of a joint family. Hindus get a joint family status by birth, and the joint family property is only an adjunct of the joint family. With this, we come to the end of today's lecture. Thank you very much.